like to ask each of our panelists very briefly for their key takeaways or their final thoughts. James, we heard from you first. Perhaps you want to give us a few of your closing thoughts from today's presentation.
If you're writing an IPR petition, if at all possible, try to use only patents, U.S. or foreign patents as prior art, and don't use printed publications unless you have to. And just because of the additional requirements to prove up that they were prior art, which, as John said, takes away from your word count, which can be tight already, depending on a lot of things like how many claims you're challenging, how wordy are the claims and things like that. They all go towards your word count. So if you don't, it's better if you don't have to address that in your petition. But if you are going to address it, make sure you walk through the legal requirements to show and submit the evidence to show that the references you're relying on qualify as printed publications, and don't give it short shrift, basically.
Thank you. Peter, we then turn to you. Perhaps you want to give us a few of your final thoughts from today.
Yes, thank you. Yeah, just a couple things. So on the issue of estoppel, I think the law there is still really in flux, and it presents an opportunity for both sides, patent owners and petitioners, to make some creative arguments, and there's a lot of room for creative strategy. So I think the important thing is to, particularly if you have a parallel district court and IPR action going on, is to just think carefully and creatively about the strategy and try to coordinate those two. And there's a lot of room, I think, to really effectively serve your clients and do some interesting things. And then motions to amend, I do think that that option is certainly more interesting and intriguing than it was two to 3 years ago. But you do need to really kind of think through the consequences of doing that, and consider what else is going on. For example, if there's ongoing prosecution in the same family, and what effect it will have on damages and things like that. It really need to be carefully considered before you take advantage of some of these new procedural options for maybe making the motion to amend process more effective and realistic.
Thank you. John, you are our final speaker of the day. Perhaps you want to close us out with a few of your key takeaways.
Okay, great. Thanks very much. So, kind of piggybacking on what Peter just said, one of his key points was being creative and really thinking about new ways to prevail in these proceedings. So the first one I have is, don't sleep on the discretionary denial. If you're the petitioner, you better address it in your petition. Again, word count is tight. There's a lot of considerations, but at the end of the day, you probably want to address both forms of discretionary denial up front. The board's looking for it, so I would recommend that. The patent owner, use discretionary denial as a sword to try and get rid of these proceedings early. Second big takeaway I have is to be aware of potential additional time bars. I know they're not codified, but I think they're out there. So for the petitioner, you might want to docket these dates. Other petitions filed against the patent, your own or other filings in the co-pending litigation, the status of the co-pending litigation. And again, as the patent owner, think creatively, how can you use these time bars as a sword? And last but not least, I think when you look at the 325D discretionary denial, I think that the thing that really jumps out is each panel is different. And I think that's been true among all the topics that all three of us have discussed today. Some panels are going to react one way, others are going to react another way. So at the end of the day, again, you want to be creative, take your shots. Some of them are going to work, some of them are not, but you just want to bear that in mind, that there is no right or wrong answer, and sometimes it's going to come down to your panel that you get. So that's my key takeaway, Andy.